Everybody have a seat. Good morning to everybody. At this juncture, are both sides ready? I believe we have a verdict.
Yes, sir.
Okay. So, to the folks in the audience, I said yesterday, and I'm going to repeat it in a shorter version, that we've got 6 people that were plucked out of their normal lives, just sitting at home eating a sandwich one day, and they got a card in the mail that said, "You got to come to the courthouse." They're just regular folks, just like the rest of us. And they got thrust into this situation. I have no idea what's going to happen right now. I do know one thing. There's going to be one side who's going to be brokenhearted. One side's going to be brokenhearted. We know that for sure. What I ask everybody, and then I follow it up with I'm ordering, that I am respectful that this is the most pressure-packed moment for most people in their entire lives. I don't want to hear a peep. So when the verdict comes in, and to whatever side's brokenhearted, if you don't think you can take it, I need you to step out in the hallway, because nobody will run out of this courtroom while I'm taking this verdict. As soon as the 6 jurors are out of the courtroom, you're free to get up, walk out. Please. My job, and I think everybody's picked up on it, how respectful and polite I am to everybody. But when I'm forced to, I bite. I just want peace for these 6 people to get out of here, and then whatever the verdict is, we'll deal with it after they have been excused. Okay. So let's bring in the jury.
Jury adjourned.
All right, everybody have a seat. Jurors, I'm going to take things out of order here. I want you to listen. One last instruction I have to give to you. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. Now, when you're being escorted out today, if you want to say, "Listen, I want to break off and stand in front of the courthouse and talk about this case," you're free to do so. But you're also free to say, "I've done my service and I'm leaving." If anybody harasses you, I want to know. When you leave, I'm going to give you you're going to be handed a packet. In the packet is a certificate of appreciation. Inside the envelope is a letter evidencing your jury work that I mentioned a very long time ago. If anybody has a problem with an employer, let me know. Also, there's the anonymous questionnaire. It's a way for you to write back to me and tell me, "Judge, this is what I liked, this is what I didn't like." Does all of you have your personal belongings? Everything you've gathered, everything up? They're in the jury room? Okay. Now, juror number 2, Randall, I believe you have the verdict form. Is that correct? If you please pass it to Deputy Dunkley. Mr. Clerk, publish the verdict.
In the Circuit Court of the 15th Judicial Circuit, in and for Palm Beach County, Florida, Criminal Division, Division X, case number 2016 CF 005507 AMB, State of Florida, Plaintiff versus Nouman Khan Raja, Defendant, verdict. We, the jury, find as follows. As to count 1, we find a defendant guilty of manslaughter while armed with a firearm as charged in the information. As to count 2, we found a defendant guilty of attempted first-degree murder as charged in the information. If you find a defendant guilty of attempted first-degree murder, you must next answer the following questions. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant, in discharging the firearm, actually caused great bodily harm or death to Corey L. Jones? Yes. So say we all, the 7th day of March, 2019, in West Palm Beach County, Florida, signed, jury, foreperson.
Poll the jury.
Juror number 1, were the verdicts is read your verdict? Juror number 2, were the verdicts is read your verdicts?
Yes.
Juror number 3, were the verdicts is read your verdicts?
Yes.
Juror number 4, were the verdicts is read your verdicts?
Yes.
Juror number 5, were the verdicts is read your verdicts?
Yes.
Juror number 6, were the verdicts is read your verdicts?
Yes.
Thank you very much. You're excused. Follow the deputies. All right, everybody have a seat. Mr. Lubin, you're going to want a PSI and a sentencing hearing, correct? How long do you think you need to prepare that? Could you? All right. So, state, what are your feelings? 30 days to put it off?
At this time, obviously, we're going to request the defendant be remanded.
I am going to remand the defendant.
We will, we understand that there realistically is going to be some type of legal argument that needs to be made.
Sure.
Based on the verdict, we would expect there to be some type of motions filed by the defense. We'd ask the court, if you would, set a deadline on filing motions, and then give us a certain deadline on responding to those motions, and then setting a sentencing hearing either from that point, but I think 30 days might be a little too light, just in the fact of, understandably, there probably will be some litigation prior to the actual
I'm sure.
sentencing judge.
Definitely there will be, based on some previous discussions we had. So, Mr. Lubin, should I pass sentencing off then for about 45 days to get your post-trial motions in order? Okay, so Ms. Driscoll, please give me a date in about approximately 45 days, and I'll set it at 1:30 in the afternoon and set aside the whole afternoon.
And can we also have a date, just a final date for any motions to be filed that will give us an opportunity to file?
I'll put that at the 30-day mark.
Yes, sir, thank you.
So that gives you 15 days in between. 30 days to get your appropriate motions filed, 15 days early.
Judge, are you going to do the motions at the same time as the sentencing?
That would not be my intention. That would not be my intention. So I'll have time in between there. The lawyers have worked so well together. Just contact each other, and I'll put aside special time for you. Fair enough?
Yes, sir.
Okay.
April 26th, it's a Friday.
April 26th.
Yes, sir.
That's the 45-day mark.
Yes, sir.
Okay. That'll be sentencing, 1:30 in the afternoon. And in between, I'll leave it to the lawyers to contact my office to set up whatever hearings need to be conducted regarding post-trial motions. So I hereby remand the defendant. And Mr. Lubin, do you want a PSI? Anything else I need to do this morning? So I revoke any bond. He's held no bond. I'll be adjudicating, but I'll be keeping the post-trial motions made.
So he is adjudicated today, but
Correct.
obviously we'll address that if it needs to be so.
That's correct.
And would you rather us prepare a judgment at this time, or have a judgment?
Whatever makes the clerk happy.
Yeah, I'll make sure to get with the clerk, Your Honor, and whatever.
Okay. All right, so we're going to be in recess. Everybody be peaceful, and I appreciate the attorney's extremely hard work in this matter.
Court is in recess.